Ladies and gentlemen, we have a brand new Supreme Court, and the opinion that dropped late on the evening before Thanksgiving proves it. On October 27, 2020, Amy Coney Barrett became a Justice of the United States Supreme Court. And like I set out in a previous video, it was clear that the court was going to shift in certain ways. We are now seeing the first case where Justice Barrett has caused a clear shift in the court. In addition, we now have strong evidence that the center of the court has shifted from Chief Justice Roberts, with the new swing vote probably being Justice Kavanaugh. Let's explore all these issues, but first, let's start with the actual case, which is Roman Catholic Diocese of Brooklyn, New York v. Cuomo. The facts of this case are pretty simple, so I will cover them briefly. A number of religious institutions in New York, including Catholic churches and Jewish synagogues, had been subjected to capacity limits because they were situated in what New York deems red and orange zones, meaning that the geographical location that the religious institutions were located at had increased or uncontrolled community spread of COVID-19. When a religious institution is located in an orange zone, it was limited to congregations of 25 people. And when a religious institution was located in a red zone, it was limited to only 10 persons in attendance for a service. This severely impacted the ability of these institutions to serve their congregations. For example, Justice Gorsuch observed that certain branches of the Jewish faith must have at least 10 men present at any service, so Jewish synagogues and red zones were effectively prohibited from serving women in their congregations. One more interesting wrinkle is that more or less at the same time that the Supreme Court agreed to hear the case, Governor Cuomo reclassified the zones where these religious institutions were located from red or orange to yellow, meaning they could serve up to 50% of their maximum capacity. The District Court, relying on Jacobson v. Massachusetts and South Bay Pentecostal Church v. Newsom, ruled against the religious institutions. Jacobson is a century-old case dealing with mandatory smallpox vaccination that I discussed in an earlier video on COVID restrictions that should be in the upper corner right now. South Bay, however, is a case that has very similar facts to this one. However, and this is important, that case was decided early in the coronavirus pandemic, before a lot was known about COVID, and it was decided 5-4 while Justice Ginsburg was still on the court, with Justices Alito, Thomas, Gorsuch, and Kavanaugh being in favor of striking down California's restrictions on religious gatherings. The Second Circuit upheld the order of the District Court, and the institutions sought emergency review by the Supreme Court. And that brings us to the decision. And let me start by saying that this is a 5-4 decision, and that it was issued per curiam, which means that it was not signed by any particular justice, but rather was authored on behalf of the court. And the court's primary opinion is pretty interesting. As I am sure that anyone watching this video knows, free exercise of religion is embedded in the First Amendment of the United States Constitution. There is an entire line of jurisprudence on the free exercise clause, but boiling it down to a mostly accurate core, if a rule imposes greater restrictions on the exercise of religion, or the rule is not one of general applicability, meaning that the same rules are not applied to activities other than religion, then any restriction on the exercise of religion must survive strict scrutiny, which generally means the measure will not survive. In particular, strict scrutiny means that the particular measure must serve a compelling state interest, and the challenged rule must be narrowly tailored to achieve that compelling state interest by the least restrictive means possible. Unlike in South Bay, the court found that New York was subjecting religious services to more strict regulations than other businesses. such as the businesses designated quote-unquote essential by Governor Cuomo. In particular, the court observed that certain stores could have hundreds of persons present on any given day, and that schools and factories can continue their activities with far greater levels of occupancy than religious institutions. In addition, the court found that the state of New York had admitted that these other actors had contributed to the spread of COVID, while none of the religious institutions had contributed to any outbreaks. As New York was treating religious institutions differently than other entities, strict scrutiny was applied. Now, the court found that stemming the spread of COVID was a compelling state interest, which neither side really challenged. However, the court easily found that the challenged capacity limits were not the least restrictive measures that could be implemented to help stem the spread of COVID with regard to religious organizations. Accordingly, the court found that there was a likely violation of the Free Exercise Clause and that the injunction should issue. The court also found that the case was not moot, despite Governor Cuomo reclassifying the locations where the religious institutions were situated as yellow right before the Supreme Court reviewed the case. This is interesting because the governor had already given the religious institutions more relief than they had asked for, and the court could have easily found the matter was moot. The dissenting opinions all attacked the majority for this reason. The majority opinion, however, took a different view. The court noted that Governor Cuomo regularly changed the classifications of areas, and that the religious institutions would be under a constant threat of the governor changing them again if the court did not act. And under several prior cases, this made the matter not moot. As I mentioned in a previous opinion, the court will frequently use mootness when they do not want to address the merits of the decision, and Chief Justice Roberts would have used mootness to put off addressing the merits of this case. Let's briefly talk about Justice Gorsuch's concurrence and Chief Justice Roberts' dissent before moving on to the next section. Justice Gorsuch is probably the most pro-civil liberty justice on the Supreme Court right now, so there is not a lot surprising in his concurrence other than the vigor with which he attacks dissenting justices' positions and his indirect attack on the court's prior decision in South Bay. In a very straightforward manner, he stated the court had stood aside for far too long during the pandemic and allowed certain states to trample on the Constitution in the name of safety during the pandemic. And he really was that straightforward. One of his quotes is, "Even if the Constitution has taken a holiday during this pandemic, it cannot become a sabbatical." Justice Gorsuch also attacked the precedential strength of Jacobson head-on in what will likely be one of the most quoted bits of the opinion. Why have some mistaken this court's modest decision in Jacobson for a towering authority that overshadows the Constitution during a pandemic? In the end, I can only surmise that much of the answer lies in a particular judicial impulse to stay out of the way in times of crisis. But if that impulse may be understandable or even admirable in other circumstances, we may not shelter in place when the Constitution is under attack. Things never go well when we do. Again, not surprising given Justice Gorsuch's well-documented judicial philosophy, which is that the government's power over its citizens should be severely limited at more or less all times. Somewhat more surprising is Chief Justice Roberts' dissent. Justice Roberts says flat out that he would hold the matter moot because Governor Cuomo had reclassified the locations of the particular religious institutions that challenged the restriction in this case from red or orange to yellow, even though Governor Cuomo could go back and change it again at any time. Justice Roberts would hold the matter moot even though he comes right out and says that the restrictions raise serious concerns under the Constitution, which is court speak for he believes the restrictions are way over the line. Roberts' dissent largely reflects his judicial philosophy, which is pretty well known. He believes that the credibility of the court is paramount, and he does not believe in overruling elected officials unless they commit an egregious trespass on some right. He also very clearly believes that the court should take a back seat during the pandemic to elected officials, which, until now, the court has largely done. I'm not going to cover the other dissenting opinions because they are pretty much exactly what you would expect from the liberal wing of the court. Although I will say that Justice Breyer's dissent is exceptionally well reasoned, and if you want to see the basis for the opposing view, it is definitely worth reading in full. It's only a bit over 5 pages long. Since Justice Kennedy retired, Chief Justice Roberts has been the swing vote on the court. On decisions involving abortion, healthcare, and COVID restrictions, to name a few, Chief Justice Roberts cast the deciding vote. However, that is clearly changing. And that brings us to what I consider to be the most interesting bit of this opinion, which is Justice Kavanaugh's concurring opinion. The reason that Justice Kavanaugh's opinion is the most interesting bit to me is that it reveals that he is probably the new swing vote on the court. In particular, Justice Kavanaugh indicates that he largely agrees with Chief Justice Roberts, but that he has some disagreements on procedural points. He also indicates that he is open to consider other, less restrictive measures. Neither the majority opinion or Justice Gorsuch's concurring opinion provides any such indication. Let's discuss some of the particulars of Kavanaugh's opinion. He compares the restrictions at issue in this decision with those that were at issue in past opinions of the court, i.e. a 100-person limit or a 50-person limit, and finds that the restrictions that New York imposes on religious institutions are more severe. That implies that he would consider upholding the looser restrictions. In addition, Justice Kavanaugh directly quotes from South Bay, "The Constitution principally entrusts the safety and health of the people to the politically accountable officials of the states." He goes on to observe that federal courts therefore must afford substantial deference to state and local authorities about how best to balance competing policy considerations during the pandemic. This further indicates that he is open to argument from the states seeking to impose pandemic-related restrictions. Finally, Justice Kavanaugh observes that in light of the devastating pandemic, I do not doubt the state's authority to impose tailored restrictions, even very strict restrictions, on attendance at religious services and secular gatherings alike. He then goes on to note why he believes that New York simply went too far. Accordingly, Justice Kavanaugh is the closest to the position of the dissenters of any of the majority justices. That means that, at least for cases like this one, and probably for many, many others, Justice Kavanaugh is going to be the target of arguments, as his vote is probably going to be the only one that matters. To start, I think it is too early to say that this is going to constitute a radical change in the philosophy of the court. However, this case is definitely evidence that the court has made a shift. The question is really how much of a shift. I don't think the timing of this case, on the eve of a Thanksgiving when so many state governors have imposed restrictions on family gatherings, was a mistake. Rather, I think the timing was selected to send a message. I think that message is intended to be that the most severe COVID restrictions will be overturned if they are challenged before this court. Let's run through just a few of those types of restrictions. Now, New York was one of the last states that had this severe of a limit on religious services. I could not find any state that had this severe of a restriction other than New York at this time. So I don't think that this case is going to affect the restrictions on religious gatherings that are still in place in other states, because those restrictions are so much less severe than what New York had imposed. However, this decision will also open up other challenges to COVID restrictions. I think that state home orders are done unless there's some significant change in the pandemic. For example, New Mexico's recent state home order will probably run afoul of this court if it is challenged. In addition, limits on the size of gatherings are likely to be struck down if they are overly strict. Hawaii presently has a 5-person limit on gatherings, and many other states have limits of 6 persons. I expect that if these are challenged under First Amendment grounds, this court will probably overturn them. Not definitely, but probably. In my earlier video on quarantine laws, I indicated that certain quarantine orders may stand up to challenge. For example, certain states require that out-of-state visitors quarantine for 14 days, even if they have a recent negative COVID test. Given the shift in the court, I expect that those types of orders will be struck down if challenged. I don't want to imply, however, that this court is not going to uphold any COVID-related restrictions. Justice Kavanaugh made it clear that he is willing to consider reasonable restrictions even on religious services. However, those restrictions are going to have to pass the appropriate standard of scrutiny. For example, Hawaii presently requires visitors to the state to either quarantine for 14 days or present a negative COVID test. I believe that requirement will stand up to scrutiny, even though it puts the burden on the individual to prove that she is COVID-free, which conflicts with certain precedent. Nonetheless, I expect in the coming months you're going to see the court make its presence known a lot more with regards to COVID restrictions. The age of the lockdown is not over yet, but elected officials are going to have to justify the restrictions, and if they cannot, those restrictions will be tossed out. That is all I have for you today. If you enjoyed this video, please consider giving it a like. And if you'd like to see more content like this in the future, feel free to subscribe. This channel is just a few subscribers away from 300, when I will definitely show my appreciation to all of you that have subscribed by giving away 3 Amazon gift cards worth $50 each. As soon as the channel hits 300 subs, I'll publish the details. That's it. Have a great day and bye-bye.